Inpatient when we can't find an inpatient place to
Because you're not
take them.
going to.
Yeah.
I know. Like, dang.
So much industrial land.
Oh, they made it.
Yeah, take them.
And she didn't do that mental health.
Her out from underneath the train dressed in only a negligee after she'd been there
Perfect. Good morning, Your Honor. Tim Gibbs on behalf of Chad Grice. This is 23 CF 2516. Judge, we're here for a bond hearing this morning. We filed a bond motion last week. Judge, Mr. Grice is currently in bond. He's been incarcerated since November 9th. He's currently has a present bond of $3,000 cash professional. He is unable to make that bond. It is so excessive that it precludes him from being able to furnish it. Judge, we are requesting an ROR bond or a signature bond. He has lived in this area for life. He will be living locally in Baker. He does actually have his own framing company, which is where he makes his living. He has a GED. I don't believe he's ever missed court. And Judge, the allegations in the case it is a domestic case. I don't know if I don't think I've had any contact with the alleged victim. I'm trying to check that right now. But we would also be amenable to pretrial supervision. I think he's already been placed on that, Judge, with no contact with the alleged victim until we hear from the alleged victim.
State so.
Your Honor, I was also verifying whether I've had contacts with this victim. If you I can have 1 second.
Okay. All right.
Now, I do see a note in my records that the victim wants to drop the charges. However, I haven't had the chance to verify that. So at this point, I would agree to the reduction of the bond.
All right, what'd you want it at?
We were asking for an ROR, Judge, with pretrial.
Supervision, no contact with the victim.
Thank you, Judge.
Thank you.
Okay, thank you. Send me an order.
May I call? Yeah. Judge, we are back on the record with Mr. Hunter Duell, Judge 23 CF 825. I think we have reached an agreement if I can just review that with him briefly. Okay, is that still what you want to do? So if you would, please sign right there. And then today's date, please. All right. If I may approach, Judge.
This is 23 CF 825, State versus Hunter Duell. Would you, Mr. Duell, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
All right. You want to enter a no contest plea to 2 charges of, two counts of felony battery, great bodily harm. Both of them are third-degree felonies, correct?
They are correct.
You gotta say yes or no. You have to say out loud. That's what you
Do you
want
want
to
to enter
do.
this plea, Judge?
Yes.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Gibbs has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. Sentences you to 2 years, Department of Corrections, credit for time served concurrent, followed by 8 years probation, $100 cost of prosecution, standard court costs, $150 PD fee, sex offender counseling with recommended treatment, no unsupervised contact with minors, no contact with the victim, not designated as sexual offender, $135.49 cost of transportation to Okaloosa County Sheriff's Office, adjudicated on both counts, guilty.
Judge, we will file a non-proton. One last thing, because they're both third-degree felonies. How
That's
do you
exactly,
break down the counts?
that's, that we have to break down the counts, exactly. I just realized that. Judge, if we could break it down instead, just realized this now that we've submitted it. For count 1, if we could do the 2 years DOC on count 1, followed by 3 years probation, and then 5 years probation on count 2. That would be consecutive. I can certainly make that. So how we break it down, because the maximum on each of those is 5 years. Just initial next to where I've made changes. If I may approach, Judge.
All right, I'm going to vacate that sentence that I just imposed in 23 CF 825 and start over again. What is, it says count 2, 5 years probation, consecutive squiggly marks.
Oh, the squiggly mark is his initials, Judge.
Oh, okay.
Because we changed what, after he signed it, I wanted to make sure that he acknowledged the change.
All right, so I'm going to redo this sentencing. You're in agreement with that, Mr. Duell? And you've discussed it with your attorney? All right, court vacates the previously imposed sentence and imposes a new sentence on count 1 under 23 CF 825. 2 years, Department of Corrections, credit for time served, concurrent with count 2, followed by 3 years probation, $100 cost of prosecution, standard court cost, $150 PD fee, sex offender counseling with recommended treatment, no unsupervised contact with minors, no contact with victim, not designated as sex offender, $135.49 cost of transportation, Okaloosa County Sheriff's Office. Count 2, 5 years probation, consecutive. Is that standard probation?
Standard probation, Judge.
Adjudicated on both, guilty on both counts.
Thank you,
Is that
Judge.
it? Okay, thank you.
Maybe probation real quick, okay. And I think that completes my business for this morning, Judge.
All right, thank you.
And Your Honor, will request for supervision please be waived,
All right,
I'm ready.
and there is no GPS, is that correct?
It was not a downward departure, and
Yep.
the alleged victim was over 15, so GPS is not required, Judge.
all right.
Thank you, Your Honor.
Okay, Mr. Williams.
Thank you, Judge.
Yep. So it's 2 years to the count.
So no prison.
No prison.
Oh, I thought, I thought she had had all of hers. I misunderstood when I asked her then. So yeah, she can go ahead and do hers. Oh, I see what you're doing. All right.
Meantime, no, that's Ellis.
Thinking lunch?
Doesn't look like it. No, I got hearing, so.
Mine only took 5 minutes. Well, I'll see y'all back over there.
You ran out?
One left on me. And I
Are you Mr. Hart? Judge, we have several cases on Mr. Hart, including a case scheduled for arraignment this afternoon. What I'd like to do is enter a denial on the violation of probation cases and go ahead and arraign him on the felony case, and then just have the two groups of cases tracked.
All right, this is 2023 CF 2395, Colby Lee Hart, correct?
That's correct, Judge.
And he is here on arraignment of battery on an officer or firefighter and assault on an officer or firefighter, and also violation of probation. So you want to enter a not guilty plea on those cases?
That's correct, Judge.
Yeah, we'll set him for, what you want, February 26th on everything?
Yes, sir.
That's fine, Judge.
Okay, February 26th. Public defenders appointed, pled not guilty. Okay?
Did you sign? Did Jay sign? All right, I'm gonna head back to the office. See y'all. You can lunch text.
Okay. All right, Judge, Mr. Howman is here for a motion for bond reduction.
Zachary David Howman, is that right?
That's correct, Judge. I filed a
Okay.
written motion. If we can have him sworn, I'll ask him some questions.
All right, Mr. Howman, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God. Okay, thank you.
Mr. Howman, let me ask you a few questions. Looks like you've been incarcerated since about November 11th, is that right?
Yes, sir.
And you currently have a bond on this case of $29,000. Are you able to make that bond?
Not at this time.
And what bond are you requesting?
Actually,
You'll have to
third thing, the
speak
federal
up, because I
probation thing
can't
has
hear you.
changed. They placed a hold on me Monday.
All right, so you
That's-
have now a whole...
Yes, sir.
All right, do you understand if the judge, or if you bond out, that then you'd be in federal custody
Right.
and you'd be dealing with that case before you finish
That's-
this one?
Right, that had just changed before we talked the last time, so.
All right, do you want me to cancel this bond hearing then?
can, yes, sir.
All right, let me
All
just
right.
cancel the hearing then.
Okay, thank you. Thank you, sir.
Yes, sir.
Thank you. And I'll make a note in the file,
All right,
okay?
thank you.
This afternoon.
I think she pled into drug court yesterday.
She did.
So she doesn't need to be transported. She should be out, actually.
Yeah, it may be a scrivener's error, in which case it needs to be fixed. We received information just before close of business yesterday that she was pled into drug court. So she's now a drug court client.
Okay. All right, well, good.
Is it? Okay, thank you.
I'm just gonna,
Okay, what next?
Does he just confirm she's out, which explains why she wasn't on the transport?
it would be
Yes,
hard for them to transport her under those circumstances. This way. Judge, she's informing that on this is a violation of probation. They'd be prepared to proceed with the sentencing today.
This is probably,
The allegations are, and the underlying charge is.
yeah, we can do it today.
All right, Judge, do you want to do a colloquy on her, or
Miss,
have me do it, or
Laird.
just change the plea agreement to straight up plea? Okay.
And if I could just ask the court to review the VOP affidavit, pretty
I'm
much
not-
will summarize.
I'm not agreeing to anything up here. She's just going to plead to me, and then I take a look at it.
Yes, sir.
All right, Ms. Lair, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes, sir.
This is 2020 CF 715.
All right,
State
ma'am.
versus Dena Lair.
Ma'am, you understand that by entering a plea straight up to the court, you're giving up your right to contest whether or not you did the things that they claim you did in the allegation.
Yes, sir.
Okay, that you violated your probation.
Yes, sir.
You understand the court's going to be able to make a finding that you did in fact violate your probation, and that although you'll have a sentencing hearing and can address the court, you won't have an evidentiary hearing.
Yes,
You
sir.
understand that? All right, you also understand that by entering this plea, you're saying you're satisfied with my advice and services, and that I haven't used any kind of pressure, force, or coercion on you to make enter that plea. I'll point out that I just suggested to you that we put the case off for a couple of 3 weeks until the next date, and I would go out and I'd show you the documentation that in fact you did plead to the felony and not to the misdemeanor.
Yes.
Okay. Are you doing this because you think it's in your best interest?
Yes.
All right, now you understand that the maximum sentence on this case is 5 years in state prison, a $5,000 fine. Nobody's saying that the judge would impose that, but that's the maximum, and he could impose that.
Yes, sir.
Okay. All right, Judge, with that, ma'am, if this is what you want to do, let me get your signature right there. Okay. Is it okay with you if I date it for you?
Yes.
All right.
Score sheet.
All right, Ms. Lair, do you want to enter an admission to violation of probation?
Yes, sir.
Did you read and sign his plea and sentencing agreement form? You understand the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams has done for you on your case? There's no agreement as to a sentence, so you're pleading straight up to me. I could give you 5 years down to dismissing the VOP. You understand that? 5 years DOC down to dismissing the VOP, or up to 5 years Department of Corrections. You understand that? Okay, let me look at her affidavit, what she did. What is this defense asking for?
Judge, I think what we're going to ask for is time served. It was an absconsion. It appears that there's no transport order, so I'm gathering that she was either picked up here, or did you turn yourself in?
I was picked up by an officer out of Tallahassee.
And she scores 42 points, so she's not in a position where the court would have to impose a state prison sentence. What the state was originally asking for on it was 6 months county jail. And when I spoke with her outside, she did express some confusion, was thinking that she had pled to a misdemeanor. Although there's not a judgment and sentence in the file, the probation officer reflects a felony, the clerk's notes reflect a felony. There's no dismissal of the felony, there's no memo sending the case to county court or anything along those lines. It does look like there was not a written plea agreement at the time of the original plea, at least there's none in the file. There is a guideline score sheet in the file.
And what is the state asking for?
Your Honor, there is an order of probation in the file ordering that, as for count one, resisting with violence, she was put on probation for 3 years. And for that charge, she was being arrested for fighting with another person, and officers tried to apprehend her, and she kicked 2 officers and bite the officers. This went on for some while she was detained. They tried to put her in the car, so she was kicking basically 2 officers. The main part of her probation for the 3 years was for a mental health evaluation and a drug evaluation. And she was put on probation on or about December 28th of 2020. And as of June 16th of 2021, probation labeled her as an absconder. She could not be found. She was not in any hospitals or anything. So she's been in absconding status since June 16th of 2021 after only being on probation for 6 months. She also failed to complete any of her drug evaluation and treatment. She failed to complete her mental health evaluation. I'm not going to ask the court to make a consideration, but on the court costs, but she did fail to pay those as well. But as for, she also failed to perform job searches as required, and failed to comply with instructions by not remaining at her home. And I can approach with the violation affidavit, but that's the main part of it. Probation is recommending incarceration because clearly, I mean, she's been in absconding status. She admitted she was picked up in Tallahassee.
I was picked up here in Okaloosa County.
She said the officer was from Tallahassee.
Right, okay. So she's been in absconding status for 2.5 years. So I thought 6 months was reasonable. I don't know how much credit time served she had previously. She was arrested on this violation of probation. Let's see. Picked up November 13th or November 12th of this month. So she's only been in custody for this VOP for 2 weeks. The state was asking for an adjudication, 6 months, OCJ, revoking term.
What do you
If I
say?
can be heard, Judge?
Yeah.
Judge, here's a copy of the violation warrant that was signed by Judge Flowers on June 28, 2021. You'll note that there's no allegation that she failed to get her mental health counseling, failed to get drug counseling, or any of the other allegations that the state's just made. I'm going to move to strike those comments.
There's an addendum violation report. So the VOP
Is there an
had.
amended warrant?
I haven't looked. This was plea to the bench that I wasn't aware of, so I'm kind of flying right now.
I put my client on the stand to address the, whether or not she did her drug evaluation, whether or not she did her mental health, checked in with mental health
All
or
right,
any
well,
of that.
tell me. Go ahead. Did she?
All right, Ms. Laird, you've already been placed under oath. You've heard the allegations made by the state with regard to whether or not you did your drug evaluation, did your drug treatment. Tell the court what you did.
Yes, I done my drug evaluation and my Bridgeway over at Bridgeway here in Crestview for my psych evaluation. I did do those. And I do have records at my home that I have done those.
Did you provide any of those records to probation?
Yes, I did. And I provided that I did not have a place of residence, and she never wrote that down either. Because I was homeless at the time, too.
Probation have a copy of that completion or?
She should, sir.
And Your Honor, this is the problem with pleas to the bench the day of, because if I'd have known this was going to be contested, I would certainly have the probation officer here, but no information like that has been provided to me. This addendum of the probation violation was dated September 26th. So I don't have any information. If they're contesting this violation, we need to either set it for a hearing, or we'll have the probation officer come in so the probation officer can either agree or disagree with the defendant's statements that she's completed this.
Well, I'll defer sentencing to, Want to go December 27th?
That's fine, Judge. We've got to be in court that day anyway.
All right. She did those things, she did them. If she didn't do them, then she just told me she did them and she didn't, so.
And I would ask the court
Take all
to
that-
have
take all
defense
that-
counsel provide me with those records
Yeah,
because
we'll take all
probation
that
has
into
not.
consideration.
Judge, I don't know.
Well, Mr. Berry can get in contact with her probation person, and they can say whether she did it or not.
That would be my suggestion.
Can I inquire with her where she thinks she did it? Bridgeway? We will definitely get in touch with Bridgeway, and we can provide that information to the court at time of sentencing, which is December 27th.
Yes.
That's
Thank
fine,
you,
Your
Judge.
Honor. Will that be a 2-year, Honor?
Here's your paperwork back. She's pled, so now it's just an issue of what,
Should I take the score sheet as well?
no, because she,
If I can just address the warrant issue. When we submit the violation report with her absconding, and then we can't find her for a period of time, and then it comes time for her to terminate supervision, because we can't find her, then we go back and review the file again, and now we put everything on there. If she did the treatment, if she didn't do this and didn't do that. So there wouldn't be a new warrant. There would be an amended affidavit saying she didn't do these other things, but we wouldn't ask for another warrant.
okay. Well, y'all check it out and let's see what she did or didn't do.
All right, Judge, thank you very much.
Okay, thank you.
Okay, Ms. Laird.
Leslie Livingston.
Judge, this is another straight-up plea to the court. Is that what you want to do, ma'am?
Yes, sir.
Okay.
Is it my case?
All right, Ms. Livingston, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God.
Yes, sir.
You want to enter an admission that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
No, sir.
Well, you have the right to have a hearing in front of me.
Oh, yes, he read them
Yeah.
to me. I'm sorry.
Okay, so you
Yes.
understand the rights you're waiving by
Yes,
entering
sir.
this admission? You can put your hand down.
Okay.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir. Thank you.
You know that there's no agreement as to any type of sentence. You could get 5 years in prison or probation terminated, I guess, or dismissed. That range?
Your Honor, her guidelines are actually going to be right around 20 months, Department of Corrections,
Oh, 21 months?
20 months, 19.35.
19.35, okay. So you understand that? There's no agreement as to what I can sentence you.
Yes, sir.
All right, court finds the plea is freely and voluntary, or the admission is freely and voluntarily entered, court accepts it. What is the defense asking for?
Judge, let me just inquire the defendant. Ms. Livingston, what is it that you're wanting the judge to do? And please explain to the judge why you think that's more appropriate than the 24 months the state was seeking.
Sir, I still have custody over my kids, and I've never spent more than 4.5 months in jail. That was in 2013. I am very sorry for what happened. My little boy has asked me, Mama, when are you going to be out of jail? They feel like I've been gone for a year. I've been gone for 5 months. I don't want to tell my little boy that I'm going to be gone for 2 years, for 5 years. That's the real reason.
I still have custody, their dad has custody, and that's where they're at. I wasn't able to put them in school this year because I got arrested. So they're spending the remainder of the year at their dad's until I come home. But normally, I'm putting them in school. I've raised my boys up to this point. I fought a custody battle. I won my DCF case. I got put on probation. I did 18 months of the probation, and I messed up. I got in trouble after 18 months. I lost my driver's license from an accident that actually happened back in 2012. Alabama and Florida connected, and they took my driver's license, and my boys ended up spending the very end of the school year finishing school with their daddy because I didn't have a driver's license. So if I was late to school, I couldn't take them to school, so I let them finish there. It was going to begin this year. But my kids were not at home. I got depressed. Honestly, I wasn't totally ready to quit when I worked my case plan, but I did quit. So now I'm absolutely ready to be clean and sober. I have absolutely no desire to do anything that's going to take me away from my boys.
How have you and your husband been dealing with the time sharing? Or is it husband or the ex-husband?
He's my ex-husband, yes, sir. Very good, very good. Brian has brought them to visit me in Santa Rosa County, not like through the video screen. We do very good. We used to have a hard time with the beginning of the custody battle. I had a history of him some abuse, but we've worked out our parenting issues. There's a shared parenting plan. We both have joint custody.
Okay. And do y'all just cooperate in terms of,
Yes, sir.
Time sharing, and are you on a rigid plan?
No, we cooperate.
Okay. Now, let me ask you about these cases in Santa Rosa. It looks like you were arrested on 3 different charges. What happened on those cases?
Yes, sir, that's the actual violation. I did 90 days in Santa Rosa for those charges.
Was one of the charges dismissed?
Yes, sir. The possession was dismissed. I'm not sure what the possession was, if that was marijuana or if that was the speed. But there was nothing there. And I had a marijuana card, so when they brought me my marijuana card, they threw out the possession charge.
Did you finish your sentence in Santa Rosa before being transported over here?
Yes, sir.
Okay. Is there anything else that you want the judge to know about this situation?
No. I trust your judgment. I
State, sir.
trust God.
And Your Honor, frankly, we were not ready for sentencing today. We did not know we were doing that today, so the state cannot vouch for the truthfulness of statements as far as compliance with DCF or what has happened in Santa Rosa. We can advise the court that she was given an opportunity to make it in the community to seek some help with her problem, yet she still tested positive for methamphetamine. Her record indicates that she had a minimum guideline of 19.35 months. Based on the fact that she still continued to test positive, the fact that she did not comply with supervision continuously, probation board has recommended a period of incarceration. The state is seeking 24 months incarceration. Gave her the opportunity to do it in the community, gave her the opportunity to get some help. Yet when she was confronted by law enforcement, she resisted law enforcement, she failed to comply, she got the new charges, and they were drug-related and then tested positive. So we do not feel it's appropriate to keep her on basic supervision at this time.
How much time has she done?
Ma'am, Judge, I haven't sat down and figured it out, but ma'am, how much time have you spent in jail total on this case, you think?
Since June 23rd.
Well, I mean, or including
And-
your original arrest.
Oh, It took me a year to get my kids. I got placed on probation.
Well, I'm talking about how
around
long were you
February.
in jail?
In jail, about 5.5 months I've been in jail.
Your Honor, I would also point out that this is not Ms. Livingston's first run-in with the court, so resisting with violence, battery, tampering with evidence, resisting without violence, and that's really what brings.
You mean the ones?
Give them plenty of opportunities to show you'd like to make
Except for the rest.
Judge, we believe those charges are the ones from Santa Rosa? Well,
May I speak?
they'd be included in the priors for today.
These were prior
Prior to that?
to her NCIS.
May I speak?
Okay.
I had one prior in 2013. These other charges are the ones that I just recently got arrested for in Santa Rosa County. That's what I violated with, was those charges, yes, sir. That I did the 90 days on.
Well, I'm going to revoke and terminate and sentence you 22 months Department of Corrections credit for time served, $100 cost of prosecution, $150 PD fee. Okay?
Thank you, sir. Yes, sir.
Outstanding monies to collections, Your Honor.
Yes, sir.
Thank you very
Good luck
much,
to
sir.
you, ma'am.
Thank you. I appreciate you.
No, you're welcome. Anytime. Hopefully never again.
Vicente Martinez.
Judge, this is going to be a plea.
Look, stay out of trouble. All right, this is 22 CF 1379, State versus Vicente Martinez. Would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God.
Yes, Your Honor.
Okay.
Just give me just a moment. I printed out and then picked up the written plea agreement on the break. Just trying to lay my hands on it. This file is... Judge, what he's going to be sentenced to is 30 months with no supervision to follow.
You want me to put it on record? Your Honor, the agreement between the state and defense is for count 1, which is aggravated assault by threat with a deadly weapon. He would be adjudicated guilty, sentenced to 30 months in the Department of Corrections, given credit for all time served. He would also forfeit the weapon and pay $100 court cost, or $100 cost of prosecution and court costs. As for counts 2 and 3, those are both misdemeanors. Count 2 is resisting an officer without violence. We are agreeing to an adjudication of guilt, credit time served. And for count 3, retail petty theft less than $100, that's a second-degree misdemeanor. We are agreeing to an adjudication, credit time served.
I found it, Judge. He's signing it now. I went over it with him in lockup.
What'd y'all find out about those points?
I had reviewed this in January and sent the corrected score sheet to defense in January of this year. I'm not sure if that was received or not, but we did receive the JNSs that Mr. Vicente was asking about. And so it was correct. It lined up.
I went out and saw him, yesterday and went over those JNSs.
What he said was true?
No, sir. There was some cases that had been resolved as misdemeanors in Texas, but those were correctly on the score sheet. I don't know if he had seen the score sheet that had been corrected from last January, so that may be where the confusion was.
I think he had, because when I talked with him, out at the jail, he pointed out that the score sheet that I was talking about was more points than what I'd spoken with him before. And so I went back through and I found the more recent score sheet, so I must have gone over it with him.
All right,
He
so
had the right.
He had the correct, was the lower points?
Yes, sir.
It's been the same score sheet since January of this past year. And with the correct, we got the JNSs to show him
All right.
that what we had on the score sheet was correct.
Okay,
And I don't think he's challenging it at this time.
No, he's not.
all right,
Thank you, Your Honor.
okay.
Okay.
Thank you, sir.
He's watching this transaction happen over there.
11:30.
Aaron's out, so she just brings it.
Yeah, just write it in there. That means you're not going to get the machete or the hatchet back. Go ahead.
I get credit for that.
Yeah, you always get, everybody gets credit for time served unless they waive it. Just
Where I added in the
initial.
weapon.
All right.
All right, we got that straightened out now?
Yes, sir.
Okay. All right, Mr. Martinez, you want to enter a, let's see, is it no contest plea, or?
It is, Judge, I'm sorry. I missed that one. But it is no
And,
contest. I've never pleaded anybody guilty.
I noticed. All right, so aggravated assault by threat with deadly weapon, that's a third-degree felony. Count 2, resisting arrest without violence. First-degree misdemeanor retail theft, less than $100, a second-degree misdemeanor. So you want to enter a no contest plea to those charges?
Correct, Your Honor.
And did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No.
Are you happy with the work Mr. Williams done for you on your case?
Yes.
Court finds the plea is freely and voluntarily entered. Court accepts it. Sentences you in count 1, you're judged guilty. 30 months Department of Corrections with credit for any time served. $767 court costs, $100 cost of prosecution, $50 PD app fee, $100 public defender fee. Count 2 and 3, adjudged guilty, sentenced to credit for time served, forfeit the weapon. And what's VR? Oh, that's just
that's his initials.
Initial, okay.
Yes, sir.
And adjudicated on those, all 3 counts. So how much time have you got already served?
18 months, 9 days,
18.
557 days today.
Well, you're probably going to get out very quickly. And stay out of trouble. You got kind of a, you're sort of developing too big a rap sheet, okay?
Yes, sir.
You may get a lot worse time in the future. Don't mess up in the future. You're smart enough not to be doing this stuff.
Yes, sir. Thank you. If I may, the reason I was trying to get mental health is because of bipolar with the family, but basically my father's taught me that no matter where I go, the problem isn't where I'm at, it's me. And so I'm taking this time to make a plan and try to just adjust my attitude and my behavior to be a law-abiding citizen with society.
Okay. Well, good luck to you. Thank you.
Thank you.
Good luck, Mr. Martinez.
Mays.
right, you are Justin Mays? You're
Yes, sir.
Justin Mays? Okay.
If you'll give me just one moment, Judge. Judge, I met with him, I've met with him several times, including yesterday and again this morning. I've gone over his rights with him. We have finally reached an agreement, and he's going to accept it. Okay, do you mind if I date it for you, sir?
Yeah.
Okay.
It's the 30th.
Yes, sir. There you go.
All right, Mr. Mays, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes, sir.
Okay, thank you.
Yeah.
Can I ask you a question?
It's going to be up to the state president of the county to call it. But hang on, the judge still needs to read it into the record.
All right. Mr. Mays, you want to enter,
He's entering a plea to counts 2 and 3. The state's going to dismiss count 1, Judge.
all right, the no contest plea to count 2, battery of a jail employee, and count 3, battery of a jail employee. You understand that? Both third-degree felonies?
Yes, sir.
Yes, sir.
Did you read and sign this plea and sentencing agreement form? Did you read and sign this form?
Yes, sir.
You understand the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case?
Yeah.
Okay.
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count 1 is going to be dismissed, correct?
That's correct, Your Honor.
On count 2 and 3, sentences you to 20 months Department of Corrections concurrent on each case with credit for time served concurrent. Standard court costs, court reserves on restitution, $100 cost of prosecution, $150 PD fee. Submit to medical testing for a communicable disease in Okaloosa County Jail if requested while in custody, and adjudicated on both those counts. And credit for time served, if I didn't say that.
Yes, sir.
Okay? All right, thank you.
Okay. All right, sir. Good luck. Nicholls?
All right, Jared David Nicholls.
Judge, we've been trying to get Mr. Nicholls into Phoenix House. We did get the application back from him, and it has been forwarded to Phoenix House, but we don't have a decision from Phoenix House as yet. So we're going to need to pass him out.
How much time you need? I go December 27th?
Excuse me?
What day, December 27th?
Yes, sir, I think so. My experience with Phoenix House is it takes them more than a couple of weeks.
That's what I thought.
Otherwise, I would say December 7th. If we have a date between the two, I'll take that.
Well,
But
if you
if
get
not,
it quicker, we can move him up, but December 27th.
all right, Judge.
Thank you.
Okay, well, if you get something from them directly to you, because you put your own application, and we've done one for you. Send a jail communication, and I'll try to slide you in on an earlier date, okay?
Next.
That's all I got for Mr. Williams. That should be Odom with Mrs. Rivers. Mr. Odom, you stand at that lectern, please, sir.
Your Honor, we're here today on the case of Randall Jackson Odom, 23 CF 1947. We're asking the court to reconsider our motion for bond reduction. Mr. Odom was taken into custody back in August. Prior to his arrest, he was scheduled to go to an oncologist for the return of his throat cancer. His bond is at $50,000 for count 1, $25,000 for count 2. He's a lifelong resident of Okaloosa County. He has grown children here. He has previously requested the court lower his bond so he could get the cancer treatment. I had brought the medical records. I have them again. And the court denied the request. When I saw him last, they had discontinued even his daily blood pressure medication. So he was not getting the treatment. Someone in the audience had said something to us about him going to the hospital, that he had to be rushed to the hospital, so I was asking about that. Mr. Odom has been writing me letters saying that the pain is excruciating. He is just asking to be able to get out, to get treatment. He's willing to wear an ankle monitor. He just wants to be able to get treatment.
What does the state say?
Your Honor, he was out on bond in 23 CF 730 for possession of a firearm by a convicted felon, and he picked up the false imprisonment and sexual battery charges while he was out on bond. He has a criminal history that includes felonies including dealing in stolen property, grand theft. He also has several misdemeanors. He currently scores 132.3 months in prison, and so because of that, the state is asking that the bonds remain the same as previously set.
I mean, he can't get medical treatment at the jail?
And Your Honor, he's made all his prior court dates on his other case. And he has indicated to me that the felonies were really old, is that correct?
About 30 years old, yeah.
He says about 30 years old. He's just asking for treatment.
I mean, he's currently charged with, what?
He's currently, right now he has 2 cases that are open. One's possession of a firearm by a convicted felon, and the second one is sexual battery by threats of force or violence likely to cause serious personal injury and false imprisonment.
I'm going to leave the bonds the way they are. Thank you.
Oh, and one other thing. I'll bring it to you. I brought the speedy trial information, but I'll just give it to you later. Okay.
Oppenheimer.
Oh, here it is. Dismiss the part where I was saying you have to agree to everything.
James Oppenheimer.
That's correct, Your Honor. He's before the court on 23 CF 278. We've reached an agreement in this matter, if I may approach. I do need to tell him one thing. Okay.
All right, Mr. Oppenheimer, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Sir.
This is 23 CF 278, State of Florida versus James Lee Oppenheimer. And Mr. Oppenheimer, you want to admit that you violated probation, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. I'm going to reinstate and convert remainder of probation to community control, complete all original terms and conditions, additionally enroll in substance abuse mental health treatment previously recommended by Bridgeway, must enroll within 30 days, waive cost supervision, $100 cost prosecution, $150 PD fee, adjudicated guilty. Okay? That it?
Yes,
Okay,
Your Honor.
thank you.
You'll need to see him and him.
Your Honor, we will ensure that we get him down there to Bridgeway or wherever for the evaluation. We can't promise that they will have him in treatment within a certain amount of time.
And I mentioned that to him as well, that Mr. Berry would mention that to the state, so the state would know that
Okay.
it may not be possible. All right, that's saying you're one police straight to the judge.
Victoria Palmer.
Your Honor, this is Victoria Palmer before the court on 23 CF 400, 23 CF 437. She has indicated that she wants to enter a plea straight up to the court.
Right, this is 23 CF 400, 23 CF 437. You're Victoria Ann Palmer.
Yes, sir, I am.
Would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes, sir, I do.
And Your Honor, here is the plea agreement saying a plea to the court and her score sheet.
You want to admit that you violated probation, correct?
Yes, sir, I do.
Did you read and sign this plea and sentencing agreement form?
Yes, sir, I did.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir, not at all.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
I am.
You understand there's no agreement as to a sentence, and I can sentence you up to, what's the guidelines on this?
Did I give you the score sheet, Ms. Rivers?
You did. You have the score sheet, Your Honor. I think the maximum could be 10 years.
Yeah. Okay, these are both third-degree felonies, so you understand I could sentence you to 10 years in Department of Corrections?
Yes, sir, I do.
All right, court finds the plea is freely and voluntarily entered. Court accepts it. What's the defense asking for?
Your Honor, Ms. Palmer is asking for the court to release her back out to probation or
community control.
or community control.
And I'll do community control as well.
And you've been in how long?
I've been in, it'll be 59 days total. I've done community control before in Santa Rosa County, and I did very well, sir. I did 3 jobs. I actually got early termination with a recommendation from my officer. He called the court personally and spoke to the judge over there. It was 10 years ago, but I did complete with recommendation, and I think I could do very well with community control. I'm going to be going to rehab regardless because my situation, the drug test that I tested positive for, it totally has just threw me for a loop. And it's like I'm slammed up against the wall. I can't even breathe thinking about what was in my system that I did not knowingly put there, and it terrifies the life out of me. So I'm going to be seeking treatment, possibly in-house treatment, with my private insurance that I obtained before I came here because I already knew that this cycle's got to break. I got children, and I want to live. I don't want to die. I don't want to be a statistic. But I think I could do well on community control. It grounds me, it structures me, and I don't want to go to prison, and I certainly don't want to die.
What does the state say?
Your Honor, Ms. Palmer was on probation until June 25th of next year, and she was on for, looks like, battery upon a jail visitor or other detainee, possession of drug paraphernalia, driving while license suspended, and possession of a controlled substance. The violations was, as Ms. Palmer mentioned, for positive drug test and also for absconding. The probation officer notes in the affidavit that she did not report October 11th of this year as instructed, and her family said they had not seen her in, quote, about a week, and they were unable to contact her or locate her, and she did not contact their office, and probation is recommending incarceration and revoke and termination if incarceration is imposed. The state had offered to revoke in term with 4 months jail, and there is also an $89.45 cost of transportation to the sheriff's office, and then there would be a cost of prosecution as well. That would.
You did on the plea.
You did,
agreement,
okay.
the
That
cost
would
of transportation.
That would be the state's request. I'm trying to see where she was transported from.
Santa Rosa.
Santa Rosa County. Okay.
How much?
And Your Honor, she's indicated that she has obtained her driver's license now, so she's no longer driving with a suspended license.
I was making arrangements. That's about the time that I contacted the state attorney's office that they're saying that I did not. I spoke to the lady who answered the phone because I was trying to let them know that I had signed up for the rehab in Bay County, trying to figure out if I would be cleared to go ahead and go to the rehab or if I needed to turn myself in, and I spoke to them at the jail. So I didn't think that I had absconded because I had the warrant. I was aware of the warrant, but I was trying to get things situated personally to be able to get into treatment as quickly as possible because this fentanyl epidemic is so bad. It is so bad, and I want to live. I have a job.
How much time has she served in jail?
How much time have you served in jail?
It would be from February 15th to March 2nd, I think, and I got arrested October 19th in Santa Rosa County, so it's like 43 days this time. My mom has got heart problems, and she's got my autistic son at home. I actually have my friends taking care of the lady that I live with. She's 79 years old, and it's just I have responsibilities, as does everybody. And I know that I made a mistake, but I can promise you this girl will not be doing no more drugs. I'm paralyzed in fear.
Well, I guess I'm gonna revoke and terminate probation, new term of 2 years, community control, have a substance abuse evaluation within 30 days, begin any recommended treatment within 60 or as soon as possible. Waive cost supervision, $89.45 cost transportation to Okaloosa County Sheriff's Office, and other standard terms of community control. Okay?
Yes, sir. Thank you.
All right.
So you'll have to sit down.
Thank you, Ms. Reese.
Mm-hmm.
Thank you, sir.
Just stand right there. And that brings us to Purdue. Purdue?
Your Honor, this is Larius Purdue, 22 CF 2008. We were before the court just recently, and we were inquiring as to his status of his restoration training, because we had not gotten the sheet from Mr. Sanchez saying if he believed he was ready to come back to court and be found competent. After court, we did get a copy of the recommendation from Mr. Sanchez saying that he does believe that he is ready to go forward. However, he does say in the letter that he needs to be evaluated by a mental health professional for an additional evaluation. So Ms. Glisson and I did stipulate to who would do the evaluation. We sent it in to Your Honor, and Your Honor did enter an order requesting an additional evaluation be done. There just hasn't been time yet for it to be done. So I would ask to put him on in early January.
No objection, Your Honor.
January 4th. Okay, thank you.
Right.
Mr. Riley.
Your Honor, this is Joshua Riling. He's before the court on 23 CF 2187. Your Honor, the state has made 2 different offers, both of which require him to be interviewed and apply to a program. He has applied to Phoenix House. We just haven't heard back yet from Phoenix House. So at this point, we would just ask to put him on 12/27, and if something happens before then, before the 7th, your next court date, then we would bring him back, but otherwise, just
All right.
leave him.
December 27th.
Sabo.
Your Honor, this is Dylan Sabo. He's before the court on 23 CF 609, 23 CF 2505. We've reached an agreement in this matter, if I may approach.
All right, this is 23 CF 2505, State of Florida versus Dylan Sabo. You are Dylan Sabo.
Yes,
Would
sir.
you please raise your right hand to be sworn? You swear the testimony you give for his court's the truth, so help you God. You want to
Enter an admission and a no contest plea, Your Honor.
All right, you want to admit that you violated probation in 23 CF 609 and enter a no contest plea in 23 CF 2505, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Where the rights you're waiving by entering this admission and no contest plea?
Yes, sir.
Has anyone forced you or threatened you to enter this admission or no contest plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Anyone forced you or threatened you to enter this admission or no contest
sir.
plea? You happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds that admission and plea is freely and voluntarily entered. Court accepts both. In 23 CF 609, court adjudged you guilty, revoke and terminate probation, sentence you to 90 days Okaloosa County Jail credit for any, sentence you to Okaloosa County County Jail credit for time served, however, waiving any credit prior to November 7th, 2023. $100 cost of prosecution, $100 PD fee, $50 app fee. In 23 CF 2505, judge guilty. Sentence you to 90 days Okaloosa County Jail concurrent to 23 CF 609, waiving credit for jail time prior to 11/7/23. Or 15 court costs, $100 cost of prosecution, $100 PD fee, and that's it. Okay? All right, thank you.
Sledge.
Right.
Your Honor, this is Julius Sledge. He's before the court on 22 CF 2218, 23 CF 1017. So are you wanting to sign it? Okay. Your Honor, we're going to request a continuance in this matter.
They don't want to give me no credit.
December 27th? Or February
This
20th?
is a BOP, Judge. If we could just set it on the January 4th.
January 4th, okay, thank you.
Spiro.
Your Honor, this is Michael Anthony Spira, 19 CF 2464 and 2008 1725. Did I get that right? I think that, Your Honor, I will correct that, delete that 2008. Your Honor, he's before the court on a violation of probation. We've reached an agreement in this matter, if I may approach.
All right. So this is 2019 CF 2464?
Yes, sir.
You are Michael Spira?
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give for is course the truth, so help you God. And you want to admit that you violated probation? You have to say out loud.
Yes, sir. Yes, sir.
Did you read and sign this plea and sentencing agreement form? You aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Court's going to revoke and terminate probation, sentence you to credit for time served. $90 days to pay all monies, then send to collections. $100 cost of prosecution, $150 PD fee, $89.45 Okaloosa County Sheriff's Office for transportation, and revoke and terminate. Adjudicated guilty. Okay? All right, thank you.
Stewart.
Your Honor, this is Chase Brandon Stewart before the court on 23 CF 754 and 22 CF 1397. These are both violation of probation cases in which he is being held without bond. Mr. Stewart is a lifelong resident of this area. His mother is deceased, but he still has a grandmother that's, what, 87, and has a child, and he's asking the court to grant him a bond, let him the opportunity to get out and be with them.
Well, my father, he's on a cane, and he has to take care of her right now and put on her back brace back and forth, and he's able to do it right now. I've been worried about that, and that's not just the issue. I've talked to about the offers and stuff, and I just need a bond to get out and talk with my lawyer and my civil lawyer about some things that happened with my mother.
What is the, it's no bond right now, right?
It's no bond, Your Honor. Ms. Rivers had filed the motion under the two VOP cases because the bonds are revoked on the VOPs because he picked up a new law offense in 23 CF 2380. So he was out on bond for the controlled substance, paraphernalia, 2 counts of burglary of conveyance, resisting without violence, sale and manufacture, deliver a controlled substance, or those were his violation cases that he was on probation for. And just recently, he picked up the tampering with evidence charge. Basically, the new case, he was involved in a car crash which ruptured a main gas line here in town, and then the defendant is alleged to go to a nearby store, and he's on video going into a restroom where no one else was located and flushing methamphetamine down the toilet when the officers were trying to investigate the crash that the defendant walked away from. And so he admitted to law enforcement that he flushed methamphetamines down the toilet. He does score prison. He scores 46.2 months in prison. He has several felonies, accessory after the fact to a felony. He's got controlled substance charges in his past. He's got resisting, paraphernalia. He's got several misdemeanors, miscellaneous driving while license suspended. So if the court would consider leaving the bonds as they are, considering he was on probation for 2 cases. One was from 2023, just recently he was put on probation, and the other was from 2022. And so now he's picked up a new charge.
No actual violation, I didn't leave. No, ma'am.
So the leg,
She's saying you're alleged violation, but her alleged violation
Classic. I did
for
understand that.
yeah, for
allegedly moving something in the back.
Right, and we talked about that.
I'm gonna say,
Evaluator.
$20,000 cash or professional.
he's saying
on
$20,000
each,
cash professional.
And pretrial services supervision and an ankle monitor. Okay?
Is
Okay.
20,000 on each VOP or on each case? Okay.
So you
And that keeps-
Probably
that-
get out with a bondsman for about $4,000 or something like that.
Is it possible to do a 10 on each? I already have a 5 on the new charge.
You do have 5 on the new charge?
Yes, sir.
Okay, well, I didn't know that.
Because the one violation is from a Keaton with, I didn't.
I'll say
I didn't-
15 on the other one.
So, apologize.
He's got 5 on one, is that correct?
I'll have to verify that. Have you already posted the bond on the new charge?
I have not.
I'll say 5, okay, if he's got 5, I'll say 15 on the other one.
So 115 and 15?
You got 2 charges, 15 on one, if you got 5,000, what, they said it at pretrial, I mean, at first appearances?
So I think he's saying he's got 5,000 on the new law violation, and then, so now we're here, he's got 2 VOP cases, so we need bonds for both VOPs,
Oh,
both VOP cases.
7,500 for each one.
For each one? Okay.
So that comes to 2 total. Thank you. Thank you.
Oh,
Yes.
okay. Yeah.
Who's that?
You can arraign him while we're here.
All right,
Oh, I
what's
apologize.
9 and 130, so they're gonna address the 130 right now.
Okay.
And that's the 23 CF 2380. He's been charged by information with one count of tampering with evidence.
In your honor, he would tender a not guilty plea at this time, request trial by jury.
All right, and we'll set him for February 26th. Okay?
Okay, thank you.
All right, thank you.
And Your
And
Honor,
that's
from,
5,000 on the tampering and
Yes, sir.
15,000 total on motion violations. Thank you. Thank you, Your Honor. Thank you,
from a probation
State.
standpoint, Mr. Stewart needs to understand he's still on supervision. If he does make bond, he needs to report to the probation office immediately.
Okay, and the ankle monitor goes on, how do I get to that?
They'll come out there and put it on you before you leave.
Okay, and I'm able to work on that monitor?
Yep.
Okay, thank you.
Here.
Thank you, ma'am. Sir?
Huh? Yeah.
Is it a box or something I can work with? Because I'm a hard worker, I can't fit
I know
that box
who you
I've
are.
seen.
I know who you are.
That box I've seen, I can't fit that box.
All right, just
Thank you, sir.
make sure that you
Ma'am,
report
ma'am.
to the probation
Your Honor.
office upon your release.
Yes, sir.
Thank you.
Thank you.
Talbot.
Your Honor, this is Seth Talbot before the court for arraignment for violation of probation in 20 CF 2428, 21 CF 2077, 23 CF 38. We're going to enter denial at this time and request a continuance.
All right, how about January 4th?
No objection.
Okay, thank you, sir. She's pledged you not guilty.
Mr. Terry. And your attorney case judge, please, sir.
Your Honor, this is Otis Terry before the court on 2001 CF 1929 and 21 CF 1613. So, Your Honor, I think at this time we're going to request a continuance and ask to be put on the January 4th docket.
Without objection, Your Honor. We discussed this.
Okay, thank you.
Thomas.
Your Honor, this is James Thomas Jr. before the court on 19 CF 1448 and 21 CF 1143. We've reached an agreement in this matter, if I may approach.
All right, Mr. Thomas,
Yes, sir.
would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
Okay. 19 CF 1448, State of Florida versus James Thomas Jr. You want to admit that you violated probation, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir, I am.
Court finds the admission freely and voluntarily entered. Court accepts it. Court's going to judge you guilty, revoke and terminate probation on each case. Sentence you to 90 days Okaloosa County Jail on each case concurrent with each other. Credit and waive credit prior to arrest on 10/23/23. $100 cost of prosecution on each case, $100 PD fee on each case, $50 application fee on 19 CF 1448. Okay? Ladies, what case are y'all waiting on back there?
Velasquez Carrera.
Brandon personally.
And she's waiting on Wesson.
This is.
Good morning.
Velasquez Carrera.
Your Honor, this is Wilder Velasquez Carrera. This is 21 CF 2808. We need to figure out the score sheet for him and then talk further, so I'm going to request a continuance to the January 4th docket.
All right, January 4th.
I'll be back out when I get that information. Okay.
Thank you.
Your Honor, the next one that's listed on the docket is Richard Wagner. I had set it for a bond hearing. I also filed notice of cancellation. It's my understanding that he has, in fact, made bond. He called our office. So we're just going to request to have him put on the January 4th docket.
Okay.
And then the next one would be Daniel Wesson. Your Honor, this is Daniel Wesson before the court on 23 CF 1608. We have filed a motion asking the court to reinstate his bond. Mr. Wesson is charged with possession of controlled substance. The court previously had given him a signature bond. The bond was revoked when he got his new case. Mr. Wesson is the caregiver for his girlfriend, Laura Spooner, who is here in this kind of like a wheelchair.
Called a roller-later.
A roller-later. And Your Honor, we would like to get some information from her regarding her health condition. He is asking to get out because he does need to help care for her because she has numerous health problems. When I spoke to her, she had just gotten out of the hospital. Mr. Wesson also has an ex-girlfriend that is pregnant with his child that he needs to earn money to provide for as well. And if I could call Ms. Spooner.
Well, hang on one second. He picked up, was he on probation?
No, Your Honor, he was out on bond and he picked up a new case.
Okay, what's his new case?
His new case is set for arraignment this afternoon, 23 CF 2429. And he's already been provided with that information, and he's going to tender a not guilty and request trial by jury.
So he is on 23 CF 2429. He's charged with
possession of
burglary tools, trespassing, possession of controlled substance, possession of narcotics equipment, and criminal mischief. Okay. He's pleaded not guilty to that.
Yes, Your Honor.
And his bond in that has not been set.
It was set. What's your bond in that, in this case? They did. He doesn't have a bond on the trespass on property other than a structure on a conveyance because it was originally charged differently. And then, of course, The state did not ask for a bond, did a direct issue, no capias on the criminal mischief.
What's the state asking for?
The state's asking to let the bonds remain as they are. He was out on bond from a July arrest, and then he was just picked up October 26th for the new charges: possession of burglary tools, trespass, criminal mischief, controlled substance, drug paraphernalia.
And Your Honor, and Ms. Spooner is here because she can give testimony as to what she needs assistance with from him.
Looks like she probably needs a lot of assistance. But, you know, that's his girlfriend or something, correct? It's not his wife.
Correct, Your Honor.
And notably, Your Honor, in his criminal history, he does have a conviction for a failure to appear. He has felony battery, great bodily harm, possession of controlled substance, 2 other counts of felony battery, possession of controlled substance, resisting without, false name to Leo, driving without a driver's license, battery, possession of a short-barreled shotgun, driving on license suspended, times 2, reckless driving, worthless checks, improper tag. I think that's it. That's it. He scores 23.55 months DOC.
Yeah, with all that, I think I'm going to just leave the bonds where they are. Okay, thank you.
No, he's saying he's not going to. I have a juvenile.
What was that one called?
Daquan Watson.
I even had a Watson on the.
If they did, if they didn't bring him over, can we bring him over for this afternoon?
Was he being charged as an adult?
Yes, sir.
Okay. All right, what else you got?
Your Honor, the only other thing that I have for this morning that we had set, that 2 things that we hadn't addressed. One was Tiffany O'Neill. She was number 39 on the docket. Your Honor, apparently she is taking mental health court with Judge Schlechter, so we don't have to do anything further on that. And then 46, Nicholas Schaffner. This is a case where I'm trying to get the individual brought over from prison. Each time, nothing has happened. I did get an email this morning from the sheriff's office saying that they got the order, but now that he has been moved somewhere else, so they're asking me to resubmit another order.
Okay.
But he is currently set, and we're asking it to remain set for, I think, what is it, December 7th? The December 7th docket.
All right, we'll do that.
If we could just have, yes. If I could just have him brought over for the afternoon. Yes, ma'am.
We have a 3.850 hearing this afternoon.
Yes, Your Honor.
That's the only hearing we got?
I don't know. Yes, Judge, I believe the height sentencing was bumped from the 2 p.m. docket. Does it do you have
We do have Mr. Hartzog, I believe, this afternoon, Your Honor. At 2 o'clock. That's with Mr. Shaw or Mr. Patel.
Is that a suppression
It
hearing?
was a motion to suppress the search warrant, Your Honor.
Okay.
I believe it is going, but it shouldn't have any witnesses. It should just be the argument.
Is that the gentleman charged with numerous viewing?
Yes, sir.
Okay.
Viewing and sharing, yes, sir.
So I'm guessing nobody knows anything about Ryan Hardy.
He sent an email.
Oh, he's going to